Hey, Brian Parker here. I've got the instructions for the impermissible purpose letter instructions on the membership website and this YouTube channel. This is a cool thing. Impermissible purpose, the impermissible purpose doctrine, you've heard me say it many, many times in all my other videos. This is something where a hard inquiry is placed on your credit report. A hard inquiry is something that stays on there for 2 years, and it's usually somebody contacting your credit to fish around and search around, and that's not allowed. What's called a soft inquiry within certain guidelines is allowed. A hard inquiry affects your credit scores and the impact of others to give you credit. So we want to get that off, or if we suspect that it shouldn't be on there, we have this letter, Shazam. This is for really writing to the court. It shows good faith that you didn't just sue. By the way, under the FCRA, you have a hard inquiry in your credit report, you are automatically allowed to sue, as opposed to if it's an ID theft or a regular dispute case, you have to give them their 30 days bite of the apple. In this case, there's no dispute. It's on your credit report. They don't belong there. FCRA says you can immediately sue. Belt and suspenders, that's my mantra. So send this letter first. I think 30 years I've been sending this letter, different forms. No one's ever responded. But you are writing to the court. You're showing the court good faith. So you can see the top part of that where it's just contact information. Show them everything you can. Don't give them reason, or the court reason, to say, well, you didn't give them enough information. And then your RE should say exactly why you're contacting them. And again, that big title there, Impermissible Purpose Inquiry of My Credit Reports, is emphasized, so there's no doubt what you're asking. And then I've got a nice couple of paragraphs there stating the law and saying, hey man, why are you on my credit report? I didn't give you permission to do that. However, if I did, show me the application for credit or something authorizing you to be on my credit report. To be on one's credit report, there's like 6 ways that a creditor or a government agency or even a lawyer is allowed to contact your credit report, as long as they meet these 6 what's called permissible purpose reasons. For example, you apply for a job. These days they make you fill out an FCRA application so they can check your credit, depending on the seriousness of your job and what you're going to be doing. But if without those reasons, without those legal reasons, it's an impermissible purpose. So therefore we're saying, hey, just give me a reason under the law. And you can see in my letter, I go into detail. You're really writing to the court though. You don't have to do this, but if you show a court that, hey, I didn't just sue, I asked them and I gave them information. And again, you give them all the information you can, including on this date, you did X, Y, Z. And then you say, please, I'll give you 14 days while I investigate my rights under the Fair Credit Reporting Act. An act which is there for consumer protection. It's also there for protection of the business you're making this request upon. But if they didn't follow the FCRA and snuck a peek at your credit report, that's illegal. And regardless of whether they respond or not, they're on the hook. This letter shows the court good faith and frankly does give them a chance to fix it. And if they ignore it, that's at their own legal and financial peril. Good luck. Hope these instructions help.